as in Mary. We did not introduce N. We did O.
Was there? Oh, yeah, go ahead.
We did not do P, Q, or R. We used S through Z.
Those are all photos.
Those are photographs.
A through Z with the exception of those two.
Right.
All right.
And then also photographs were A1 and B1. So the A1 through B1 were photographs.
You
Those
say
are
E,
the shoots.
E.
A to E. Alpha to A.
There was no, there was an F one.
There isn't a duplicate of E1, so
Oh, okay.
I'm not going to send it back. G1 is Dr. Philo's CV. That was not for the jury. That was merely to be introduced otherwise. H1. We're skipping H1. I1 was the Match.com emails between Claudia and Carl. J1 is Claudia's Sky Bank records. K1 is the records from St. Joseph's. L1 is the email/letter she sent to Carl and Chris Sweet.
All right. If you have
I do, if the court will indulge me here. We have no objection to photographs A1 through E1, since I guess F1 is out. Wait a minute, did I not go far enough back? Where am I not going from? I'm sorry. Okay, I'm sorry. I'm sorry. I skipped. I didn't go far enough back. Okay. Defendant's Exhibit A. I don't think that's been authenticated. That's the. There's no authentication. She just testified to it. It's just a flight itinerary. I don't think that was properly authenticated. I think Ms. Hoerig even had some problems identifying that on the witness stand. B, the cell phone records, I don't believe those were properly authenticated. D, E, F, G, H, and I, we have no objection to any of those photographs. J, K, L, and M, which were the photographs of the marital books. I don't know what the relevance is. The defendant. Yes, J.K.
The photograph of the book.
They're the books of they're the photos of the books that were the marital aids. And
You didn't mention it right now.
I mentioned them before.
but we'd object to those. They're just something that was in the house. Ms. Hoerig said she never read them, so I don't even know what. She said this afternoon she never even read them, so I don't even know what the relevance is of those. Defendant's exhibits.
O will be the next one.
O is the photo of the bullet hole, no objection. Then we skip to S.
Yes.
S, T, U, V, W, X are all photos of the basement, no objection to any of that.
Y and Z.
What was Y and Z?
They were also in the basement.
Okay, yeah, no objection to those. Then we get to defendants A1 through E1, which I already stated earlier. No objection to those photographs. G1, I don't know, that probably should not come in. That's already admitted, the coroner's verdict in the pathology and toxicology. I think that's already admitted as a state's exhibit.
No, G1 is just curriculum detail. We're not offering.
Okay, that's out. Okay, so G1 is out. H1 is no objection to that. That's a photograph. H1, no objection to. I1 is the Match.com emails. I don't think those have been authenticated in any way. Those are clearly hearsay documents. They're not authenticated. Same thing with the bank records. They are not certified copies with the seal. They are not properly authenticated. And K1, the medical records, we'd oppose those. Those are not properly authenticated. As well as L1, the emails or correspondence that she had with Bruce Rogers. I think that's all clearly hearsay and it's self-serving. Anything she's written to someone else, that's clearly not admissible. It's self-serving. And it's not authenticated either. And I would note, particularly with respect to the records, I would point to the court to self-authentication pursuant to Evidence Rule 902. Self-authentication can be done by documents that are under seal. There must be certified copies of public records. Those are copies of certified records, but they are not certified themselves in the sense that they do not have the seal. Additionally, pursuant to Rule 27 of the Ohio Rules of Criminal Procedure, the official records, and 44.1 of the civil rules, proof of an official record, you need authentication, you need the certified copy. These are not certified copies, these are photocopies of certified copies, and I don't think they've been properly authenticated. So those are our objections and those are our reasoning.
If I may respond, please. I'm sorry? Yes. Yes. Your Honor, as to the Match.com records, we believe those are admissible in part because we're not offering them from the truth of the matter asserted, which is to state whether or not people were actually in love, not in love, or whatnot. We're offering them as evidence of correspondence between two people and that it existed. Therefore, they're not hearsay. As for the Sky Bank records, we believe those are business records and statements and documents reflecting interest in properties under Rule 803.
Under what?
Rule 803. As for the St. Joseph records, we read the statute as merely requiring that the records be certified in a manner consistent with the rule, and that is met by a person giving an affidavit and being notarized on the front. We don't see anything that says it has to be an original. So we don't believe that just because it's a copy makes it invalid. As far as we know, the state's not arguing in any way that it's invalid. The records that are contained in that are business records from the hospital, and they are also statements for the purposes of treatment and diagnosis, which are all admissible as not hearsay. As for the Rogers emails, again, we're not offering them for the truth of the matter asserted. That is the content of the emails. We're offering them for the fact that they exist and that Ms. Hoerig can state that they exist. We did not use M1. N1, which would be the email the email that she sent out, the letter that she sent to Carl, we believe is admissible. It's her writing. She stated that's what she said. That's the email she sent out. By their very nature, everything Ms. Hoerig says is self-serving. In that respect, the whole purpose of an individual testifying or an individual putting forth evidence in their own behalf is to serve their own interests. So we believe those would all be admissible.
A will be out. B
Which letter are you referring to?
The last one she wrote.
Yeah, with
N1.
That's M1 and,
and as in Nancy, okay.
all right. I think that addresses all of your exhibits.
Did you say A and B, Brown? Yes, that's the travel.
All right, now, with that, the rest, with the addition of those,
Yes, sir.
all right. And do you have a motion?
Your Honor, at this time, we would renew our civil rule, or criminal rule 29 motion. Again, we do not believe the state has presented sufficient evidence that the jury, looking at this, could determine that she acted with premeditation and prior calculation and design. The only evidence that has been admitted in regards to that was her statements as to what occurred. The coroner came and gave a statement that it was his opinion that Mr. Hoerig was shot while laying on the ground, and that's why the bullet didn't exit. He also stated that he has seen other occasions when other things occurred. He also stated that it was his opinion that he was shot while leaning forward, but could also have been on the floor. The state's not presented any evidence that the act was planned or premeditated. They have speculation as to the fact that there may have been a delay between the first shot and the last shot. But again, they've got no evidence of that. Anything they have in terms of speculation, or anything they've had, according to the officer, that this was an ambush or a planned attack is pure speculation. There's been no testimony of that sort in any way. So we'd ask the court to dismiss the premeditated murder, aggravated murder charge, and just instruct the jury as to murder.
Record.
Your Honor, in light most favorable to the prosecution, there is overwhelming evidence that this defendant killed Carl Hoerig with prior calculation and design. Reasonable juries clearly defined that she transferred $9,000 to Brazil a few days before she killed him. She purchased a firearm, had a laser sight put on that firearm, practiced with that firearm, and then proceeded to shoot Carl Hoerig as he was sitting on the steps, as demonstrated by Dr. Filo and Mr. Watkins, shot her in the back, walked down 10 steps, consciously knowing that she was going to go down there and put that gun 12 to 24 inches from his head and pull the trigger, and that evidence is overwhelming medically as well as forensically by the bullet, the stippling, and the marks in the testimony of Dr. Filo. So we'd ask the court to overrule that motion.
We'll overrule the Rule 29 motion, and we'll proceed to closing arguments. And we're going to get those in this afternoon, so we'll take another just 5-minute break about ourselves and bring the jury back up and start.
Thank you.